Depositions are the opportunity for the lawyer on the other side to ask questions under oath of the other party. They are generally informal. It is a formal process, but they are at a lawyer's office or in a conference room, but they are not in a courtroom. A lot of people are very nervous about depositions, and I'm going to attempt to relieve some of that nervousness and pressure and share with you what it's really like. First, what to wear. Most important is to come across comfortable. So don't wear clothing that you are not accustomed to wearing. Don't wear a suit or a tie if you don't wear a tie in your everyday life, because what will happen is you'll be distracted and you'll be pushing and that's not what it's about, because the core of a deposition, and really what happens at a deposition, is it's the first opportunity for the lawyer on the other side to meet who's bringing this claim or who's defending the claim. Up until this point in time, the parties have simply been a name on a piece of paper. They have never had an opportunity to meet with the lawyer of the other side. So the lawyer who is taking the deposition, which is the way that lawyers say, the one who's asking the questions, their first assessment really is, how is this person as a witness in the event there is a trial? So that is the first assessment, and the first impression that you always want to make is one of being comfortable, not nervous. That's not to say you won't be nervous. It's okay to be nervous, but you don't have to overtly display it. You'll be fully prepared by your lawyer, and it is not a difficult process, because all it is questions and answers. Questions and answers. It is not tricks. It is not getting you to say something you don't want to say. And if you are properly prepared, which I hope to do here, you can't make a mistake. And you won't make a mistake, because most importantly, just be truthful. So the deposition is all about the impression that you make, and the impression that you make is that one of being comfortable going through the process. And you won't be comfortable if you're not wearing clothing that makes you uncomfortable. So be sure to wear comfortable clothing. And what I always like to say is, whatever you would wear to your place of worship if you go to a place of worship, or if you're going out to a nice dinner with a loved one, or to a family event of some type, something that you're comfortable in. You certainly don't want to wear inappropriate clothing, which I would define as shorts, a tank top, dirty clothing. You want to make sure you look comfortable and kind of put together. So let's move to the deposition itself. You will have already met with your attorney and got a good feel for the questions that you can expect at the deposition, but I always like to tell clients simple rules. And there's 3 simple rules. And if you follow these 3 simple rules, you can't make a mistake. And the 3 simple rules that I give are: first, listen to the question that's being asked. Second, take a moment before answering the question and think about the question. What am I being asked? And third, only answer the question that they ask you. Now, I'm going to go through those rules again and show you how they work, but here's what's important. At the end of the deposition, a few days afterwards, maybe several weeks afterwards, you will receive a transcript, which is just typed up questions and answers. What was the question that was presented? How did you answer it? This is what is not on the transcript. Time. There's no time between the question and the answer. You could take 30 seconds, you could take a minute, but when you receive the transcript, it doesn't say how long it took you to answer the question. There's no rush. Take your time. If you take your time, you'll get it right. So, back to my 3 simple rules. What I always share is listen to the question, take a moment before answering the question, and answer the question that they ask you. Now, as you're sitting here watching this, if you were in front of me, I would ask you a very simple question at this point in time. I would say, consider this a deposition. And if I asked you, what kind of sweater am I wearing? What would your answer be? I bet some of you said blue, some of you said V-neck, some of you said pullover, some of you said a long sleeve versus a vest. You're all wrong. Because the reality is, I said, what kind of sweater am I wearing? And if you followed my rules, you would have said, listen to the question, which you did. Take a moment before answering the question. You thought about it. And then you guessed. You guessed at what question was I actually asking. Because my question was very vague. What kind of sweater? So then you had to think to yourself, well, what kind of sweater? And whatever came to mind, oh, he must be really asking me color. Oh, he must be really asking me pullover versus a vest. Oh, he must be asking me cardigan versus some other type of sweater. He must be asking me long sleeve versus... So I wasn't asking any of those things. You were trying to figure out what I was asking. Here's the magic of a deposition. When you're the one being asked the questions, it's not your obligation to try to figure out what you're being asked. It's the obligation of the lawyer asking you the questions to ask you a question you fully understand. The only time that you can get into trouble is if you guess at what the question is. So the answer to my question, what kind of sweater do I have? This is what you should do. Think about the question. Take a second before answering the question and say, what am I being asked? And your answer is, I'm sorry, I don't know what you're asking me. Would you please ask me again? You don't have to tell them why you don't understand it. You don't have to tell them and do their job for them. And you're not being wise or a smartass with respect to that. You're simply making the lawyer do their job, because then they should say, well, you don't understand my question? No, I'm sorry, I don't understand your question. Would you please ask it again? And then the question should come, well, what color sweater do I have on? What's your answer? Blue. That's it. Listen to the question, take a moment, answer only the question that's asked. If they want to know more, is it a pullover? Is it a cardigan? They'll ask. If they don't ask, that's their problem. Because the deposition is part of discovery. If the lawyer on the other side chooses not to discover something that you think is very important, that's their problem. Your lawyer will have the opportunity to put forth your important facts first, and if the other side doesn't know about it, it's better for your case. So this is not the time where you have to worry about proving your case at the deposition. The sole purpose of the deposition is for the other lawyer to ask questions that are relevant. So those are the 3 basic rules. Listen to the question, take a moment before answering the question, and only answer the question that you're asked. As long as you don't guess, there's no question that you will get wrong. It's very simple. If it's a compounded question and they're asking, well, what color is my sweater and is it long sleeve or short sleeve? Your answer is, I'm not sure exactly what you're asking me, so can you please rephrase that? Because it sounds like you're asking for multiple questions in one question. Now, don't be concerned because I'm an attorney. I know exactly how to answer that. Your lawyer will prevent them from asking you questions that you don't understand. So your lawyer should simply say, can you please break that question down because you're asking multiple questions in one. That's what your lawyer will be right next to you. They will not allow you to make mistakes if it's a competent, qualified lawyer. And there are no mistakes to be made because if you understand every question, then you know the answer to them. It's very simple. With respect to injury cases, there's 3 areas that you'll be asked questions about. First, who are you? Why do I say that? Because right now, all you are is a name on a piece of paper, the information that your lawyer has provided to the other side, and your name on medical records, but they don't know who you truly are. So they'll ask basic, what I call pedigree background information questions. Every question you'll know the answer to. Date of birth, where were you born, where'd you go to school, highest level of education, where do you work, what's your employment status, all basic background information to fill in the gaps of what they don't know and that might be related to the underlying claim. The second part of what they will ask you is the event itself. Where were you coming from? Where were you going to? What was the purpose of your visit on the property? Whatever type of case it is, this is where you'll spend time with your lawyer, and your lawyer will be able to tell you the specific questions that you need to be able to answer. They won't give you the answers, but they'll tell you what those questions are so you can think about it. So questions that you may not have considered, like, as you were walking down the sidewalk, where were you looking? What were you carrying? Things along that line. As you were driving, what was the distance from the front bumper of your vehicle and the rear bumper of the vehicle in front of you when you came to a stop? How long were you stopped for before you felt a crash from behind? Each one is fact specific. Obviously, I can't go through all different types of cases in this forum. But after you review the types of questions for how the event happened, the third is really the most important. What happened from the day of the event until the day of the deposition medically? What doctors have you seen? Now, here's what's important. You're not being quizzed to know every single day and every single doctor that you saw every single time. The reality is the lawyer has all of your medical records and they've reviewed all of your medical records. So all they really are trying to discover is, do you have a general sense of who you saw at various times? And here are the questions. What complaints did you make? What did they do for you? What complaints did you make? What did they do for you? Your lawyer will review various medical records with you to make sure that your memory is refreshed at different time frames. But basically, you're asked to talk about the progression of your medical care. And then, as part of the third section of the deposition, you're asked at the end, usually, 3 important questions. Tell me how you feel now. Is there anything you cannot do at all that you used to do before this? Is there anything that you can do that you did before this, but you do with some type of pain or limitation? So let me take the first. How do you feel now? That means, how do you feel at this very moment? And I would qualify the answer. Well, if you're asking me, how do I feel right at this very moment? Tell them. My back hurts a little bit, my shoulder, whatever it may be. I have a headache from all the questions you're asking me. Tell them whatever it is. If they want more details, more than how do you feel right now, Then they'll ask. Second, are there any activities you cannot do at all, that you could do before? My simple suggestion is be truthful. Do not exaggerate. Do not describe a whole host of things that you used to be able to do and you cannot do it all, because the reality is there's very few people, unless you're catastrophically injured, you've lost a limb, paralyzed, traumatic brain injury, that you can't do at all. That question is, I wouldn't define it as a trick question. It would be a trick question if you weren't watching this video. But the reason why that question's asked is they're hoping you give a long list of things that you cannot do anymore, but you really can. That becomes the basis of their defense of the lawsuit, because they know their strongest defense is to suggest overreaching, exaggeration. If anything, you want to minimize those things, because their only defense, because jurors generally tend to punish people who over exaggerate, and you don't want to do that. So minimize it. So activities that you cannot do at all are likely very few, but if you do have those, be sure to share them. And the third is, what is it that you do, but you do with some type of pain or limitation? Here, I always suggest, start in a typical day from getting out of the bed in the morning, and take yourself right through the day. So if you get out of bed in the morning, do you get out of the bed with pain-free? In the same way that you did before your injury-producing event. I personally go downstairs and I make coffee, and I keep my coffee mugs on a shelf that's a little higher. If I had injured my shoulder, I would have moved those coffee mugs, or I would have felt pain every time I go to grab them. And if I move them down, there are accommodations that you made as a result of your injury that you want to make sure you describe. Talk about it through your entire day. When you shower, if you hurt your shoulders, and putting your hands up over your head to wash your hair. Everything that you can think of. But I promise you this, they will ask you anything else. Anything else. And you'll sit there and you'll say anything else. And they'll try to get you to say more and more. But what they're really trying to do is get you to say nothing else. Well, that won't be reality, because I promise you, when you're done with your deposition and you feel that great sense of relief and you exhale and you're ready to go and say, oh, that wasn't so tough, on your drive home or on your train ride home, however you get there, you're going to think of something else. You say, I forgot to tell them that. So the answer to the question is, is there anything that you can do now that you did before, but you do with some type of pain or limitation? After you give all of your answers and they go, anything else? It's very simple. That's all I can think of now. That's all. That's all I can think of now. That leaves the door open for you, so that when you remember something on your trip home, you can always add it. You don't have to worry about it. So those are the basic rules for conducting yourself at a deposition. I wish you the best of luck.